by Apollo Boya, who acts for Cherera, the vice chair, followed by Jotham Arua, who acts for Commissioner Justice Nyang'aya. He'll be followed by Jeremy Jenga, who acts for Commissioner Francis Wanderi, followed by Gordon Ogola, who acts for Commissioner Irene Masit, and then finally Mansu Issa, who will address the court on behalf of the 4 commissioners collectively, as I will be addressing this honorable court on behalf of the 4 commissioners collectively.
So are we giving each one of you 10 minutes? Or within the 1 hour? So we put there 1 hour?
Yes, we'll distribute amongst ourselves. Yes. We hope to do it within that 1 hour. Your Lordship, my lords, the first submission, fundamental submission I'd like to make is that when this honorable court retires to consider the judgment it will deliver, this court be guided by the fact that it is the position taken in this court by the 4 commissioners, being a majority of the IEBC, that should inform this court's decision, not the views of the minority. The official position of the Commission is as per the views and affidavits of a majority of the commissioners. And that has to be so in law, the reason being that under the Constitution, and in fact under the statute, the IEBC is a corporate entity. Therefore, in the absence of consensus, its decisions as an institution are by the majority. So do not depart from that principle, a principle that has found judicial anchorage and recognition in a number of decisions cited by my colleague Paul Mwangi, the minor KI decision, the Michael Kamau case, and the other decisions. Corporate decision, and that position has been addressed, and I do not want to take the time of the court by going through it again. With regard to each one of these 4 commissioners, I ask this honorable court to bear in mind that each one of them went through a very rigorous vetting by the National Assembly, at which there was full public participation before they got appointed, so that anyone who had any issue with any of them, that was the time to raise the issues. Again, the law is clear about how one can complain about a commissioner enjoying constitutional security of tenure. So do not be influenced with innuendos and insinuations about these 4 commissioners. They were vetted by the people's elected representatives. Now, coming specifically, this is the second fundamental submission I'd like to make. This so-called walking out from Bomas, look at the affidavits of the 4 commissioners. The vice chair saw 2 affidavits, so there are 5 affidavits in total. And I invite this honorable court, when it retires, to read through those affidavits in their entirety. We adopt them. We rely wholly on the averment in those affidavits. And you will find in those affidavits that all that these 4 commissioners were demanding of the chair at Bomas at the tail end of the tallying and the verification. Their narrative, which I invite this court to accept, is that they were not involved in the tallying and verification, and in particular regarding the 27 constituencies. So they were demanding of their chair, you cannot bring a paper here and tell us that these have been verified and tallied by the chief executive. The work of the chief executive is to implement decisions of the commission. He is not part of the commission, any more than the registrar, the chief registrar, implements, or any registrar of the High Court, implements the decision of the judges, not the other way around. So they were saying, we need to tally and verify the results in respect of these 27 constituencies. And the chair would not allow that, which was typical of the relationship between the chair and these 4 commissioners. And a twist is being given that it is these 4 commissioners that wanted to force a runoff. It is the exact opposite, Your Ladyship and my lords, and that is what we state in the affidavits. It is them who were asking, how do we confirm that the candidate you are about to announce has received 50 plus 1 votes? And his response was, are you trying to force a runoff? I am not conducting another election. So this acrimonious relationship is what was there between the chair and his 2 allied commissioners and the other 4 commissioners. Now, I would like to submit that the 4 commissioners were fully justified in saying we cannot own results we have not tallied and we have not verified. The law has been referred to this honorable court severally, that it is the commission that should do the verification and the tallying. This legal notice that appointed the chair as the returning officer, you've been invited to hold that legal notice, that regulation is unconstitutional and valid because it contradicts the Constitution and the Elections Act. But beyond that, it is the chair himself alone who appointed himself as the returning officer for the presidential elections. You will not find any minutes of any meeting by the commission appointing the returning officer. So quite apart from the fact that it was unconstitutional, it did not have the authority of the commission. I would like to cede ground to my colleague Apollo so that we operate within the 60 minutes accorded to us. I ask that this court uphold the position of the 4 commissioners, that the results that were announced were not the results tallied and verified by the commission. I thank you.
The Chief Justice and members of the court, without wasting more time, I'll pick it up from where the senior counsel has left. My name is Apollo Mboya. I am on record for the fifth respondent. Your Ladyship and my lords, the actions of the chairman of the Electoral Commission can be evaluated using several instruments. And I believe the first instrument that we need to use in examining the whole issues that are before this court is the oath that the commissioners take. The oath is in the third schedule of the IEBC Act, so that for every action, we juxtapose that oath to those actions, so that we test if the actions meet the tenets of that oath. And permit me to read what that oath says, and it's taken by all the commissioners. It states, I, then they say their name, having been appointed chairperson or member, as it can be, of the Independent Electoral and Boundaries Commission, do solemnly swear that I will at all times obey, respect, and uphold the Constitution of Kenya and all other laws of the Republic of Kenya. That is the oath they take. That I will faithfully and fully, impartially, and to the best of my ability discharge that trust and perform the functions and exercise the powers devolving upon me by virtue of the appointment without fear, favor, bias, affection, ill will, or prejudice. That is the promise that they are giving to the people of Kenya and to the whole world. Now, for every action that the chairman did, which I'll not go into because this particular affidavit of the fifth respondent has been cross-referenced by my other senior counsel and also learned colleagues who spoke before me. We juxtapose those actions against that oath that they took. So, for example, if we are talking about issuing a gazette notice, you look at that gazette notice with the law, then juxtapose it to the oath, if it meets that promise that they gave. Your Ladyship and my Lords, the fifth respondent is now affectionately called OPAQUE. Affectionately. I say that because arising out of what transpired at the National Tallying Center, the four issued a statement in which they said they cannot own the results that were going to be announced by the chairman, and therefore they were opaque. Your Ladyship and my Lords, that term opaque is not coming from the ordinary. It's a term that was given by the Court of Appeal when they were making a decision in another matter, which is now famous here, called the Maina Kiai matter, which when they were looking at the role of the chairman vis-a-vis the other commissioners. And the court did indicate that to suggest that one individual alone can tally and verify the votes for presidential election is to suggest otherwise, to introduce opaqueness and arbitrariness to the electoral process. Those were the words of that court. Members of the court, we might ask if the chairman has indicated from the affidavits that we have had that it was his responsibility alone to tally and verify the results. Then the question is, what were the other commissioners supposed to be doing on that election day? Were they supposed to sit at home and watch the screens just like any other Kenyans? But then again, the chairman went ahead and allocated them duties. With respect to the fifth respondent was given the role of media. In that role, the fifth respondent was supposed to explain even to the media why what they were reading, the results they were reading, are not being projected on the screens. The results that they read were not projected from Friday 13th. And when that question was put to the chairman to refresh, the chairman said, no, I'm tallying from the back end. Your Ladyship and my Lords, the sum total of this whole transaction is that the chairman usurped the powers of the commission. And it's our submission that after all is said and done, and after we get the reports of the verification, I believe that this court will arrive at a conclusion that the chairman of the Electoral Commission was actually an agent of a presidential candidate. That presidential candidate we will know by 5th of September. And if that's going to be the case, lastly, it's our submission that this court must go further and look at the theory of agency. All the conspirators that did any illegalities, all irregularities, are agents of one another. The person who benefited from those irregularities and illegalities is a co-conspirator with the persons who perpetrated it, and they are agents of one another. And for that reason, we would urge that this court makes appropriate decision with that particular issue in mind. I call upon my learned colleague, Dr. Marua, to take over from me. Thank you very much.
The Honorable Chief Justice and the honorable members of the court, my name is Jotham Arua. I appear for the seventh respondent, Commissioner Justice Nyang'aya. I will be making submissions on the following issues. Issue number 2, whether there was interference with the uploading and transmission of Form 34As. I'll also speak to the issue whether there were irregularities and whether the irregularities affected the results. I'll mention briefly something to do with the reliefs that this court ought to make, and also issue number 6, whether IBC carried out the verification exercise. So on the first issue, my lady and the honorable members of the court, the position of my client is that there were indeed interference with the uploading and transmission of Form 34As. My client maintains that this was done without the involvement of the commissioners, specifically the 4 commissioners. And it is their position, my lady and the honorable members, that it was done in clear violation of Article 81E of the Constitution and Article 86. Before I proceed, I wish to clarify that we have made reference to a number of authorities in our written submissions, but I will not refer to them because of time constraints. As regards interference with the ICT infrastructure, the Commissioner, in his affidavit, which has been filed before this court, and specifically in paragraphs 33 to 34, raises a number of issues. First, he maintains, my lady and the honorable members, that the server was accessed by unauthorized persons, and these included foreigners and some members of the IEBC. He mentions them by name. He further maintains that one foreigner by the name Gudino Omar accessed the server several times. He explains that a number of forms were pulled down and others uploaded. And he also maintains that there was revision of Form 34Bs. My lady and the honorable members, these allegations are contained in his affidavit, and I wish to point out that they have been responded to by IEBC. In their response, the first thing I wish to point out is that there is no denial that the logs that he annexed to his affidavit emanated from IEBC. The only contention being raised is how did he get them? That contention, in our humble submission, has no merit, considering, as he puts in his affidavit, that he was the commissioner in charge of ICT at the commission. If a commissioner who is in charge of ICT cannot access that kind of information, it is my submission that nobody else in IEBC can access them. The next thing that, and that admission, Madam Chief Justice and the honorable members, is found in the affidavit of Hilda Kavonga. That affidavit is filed by the firm of Iseme Kamau and Maema Advocates and is sworn on 27th of August 2022. And the admission is contained in paragraph 13, Roman 4. Beyond that, Madam Chief Justice and the honorable members, there is also an admission, and this, according to me, is a serious admission. There is an admission that the server was accessed by a foreigner by the name Gudino Omar, as mentioned in the affidavit of Justice Nyang'aya. But I wish to read to the court what he said as concerns this foreigner. At page 5, paragraph 13.7 of her affidavit, that is Hilda Kavonga, she says, Gudino Omar is the technical lead for Smartmatic, who provides support on the technology provided by Smartmatic. He's the technical deployment lead, and then in paragraph 8, she continues, they said Gudino Omar, being a technical deployment lead, His role is to deploy infrastructure, that is networks, server platforms, and services. In his capacity, he is supposed to have access to the said infrastructure to monitor by ensuring the system is properly running at all times. Now, the first point that we need to bear in mind, Madam Chief Justice and the honorable members, is, did IBC formally gazette Gudino Omar as one of the persons who had access to the server? Secondly, IBC is enjoined under Article 81E to uphold the secrecy of the vote. How secret can the vote be if it is being constantly accessed by a foreigner from a distant location? What is the guarantee that this foreigner will not grant further access to other unauthorized persons to commit all manner of mischiefs? But more important, Madam Chief Justice and the honorable members, is the complaint by Justice Nyang'aya that Gudino Omar was uploading and downloading forms. There is silence with regards to that issue. Then there was the contention that other unauthorized IEBC staff also had access to the server. And their names were provided, Madam Chief Justice and the honorable members. In the replying affidavit by Hilda Kavonga, again they make this admission, and with respect to one Abdidahir Maalim, it is argued, and I'm referring the court to paragraph 13, Roman 6 of Hilda's affidavit. She says, Abdidahir Maalim was a returning officer, and this access was limited to transmitting Form 34Bs and not to any other function. Madam Chief Justice and the honorable members, the list of all the returning officers, who participated are included in the affidavit of Juliana Cherera, and specifically marked as Annex J C2. Unfortunately, the name of Abdidahir Mohammed does not appear. It is not indicated with respect to which constituency or which county he was the returning officer. It would appear clearly that there was a lie. Beyond that, the logs that were filed by Justice Nyang'aya were also analyzed by a forensic analyst, George Njoroge, and he submitted an affidavit to which he annexed a report. And in that report, Madam Chief Justice and the honorable members, it is clarified that Abdidahir Mohammed accessed the server more than 1,000 times. The question one would ask is, why would he access the server so many times? What was he doing? Madam Chief Justice and the honorable members, it is quite clear that the server was defiled. The next issue I would wish to speak to, and I can see I'm having serious time issues, is whether the IBC verified the results. And it is my submissions that that did not happen. And I'm saying so for two reasons. First, and this is important because it's not been captured by my colleagues, according to the Constitution, it is not only verification by IEBC that is required. Verification is supposed to happen at two levels. First, by IEBC, but secondly, by Kenyans. That's why both Article 86 and Article 81E institutionalize transparency. IEBC should make sure that every processes that they are undertaking are laid bare for the public to see, so that the public can also follow the processes and undertake their own verification. For reasons that have already been explained, it is clear that this verification by the public was not possible due to the opacity that has been referred to by my learned colleague, Apollo Mboya. But then there is the issue of verification by IEBC, which also did not happen and could not happen given the circumstances of this matter. Madam Chief Justice and honorable members, you have been told how 4 IEBC commissioners were sidelined in the entire process. It is our submissions that it could not have been the intention of Kenyans that IEBC commissioners be reduced to spectators in a presidential contest. That is something which is inconceivable, and we would humbly urge this court to put a stop to this practice. There are other issues that I would have wished to deal with, but because of time, allow me to cede the floor to my colleague, Jeremy. Thank you very much.
Yes, my Lady the Chief Justice and the honorable members of the court. My name is Gordon Ogola, and I'm representing the sixth respondent, that is Irene Masit. I'll rush through my submissions because I don't want to give more time to my brothers. I've been sent here by the sixth respondent to tell the court and the whole world that she's not coming here as a second-tier petitioner. She's not coming here as a surrogate of anybody, but she's coming here as a demonstration of her undertaking to protect, uphold, and defend the integrity of the Constitution. Indeed, while taking oath of office, she undertook to carry out her duties in compliance with the Constitution. In that regard, the sixth respondent was alive to the fact that in conducting the general elections, they had to be guided by the provisions of not only Article 81, 86, and 138, but also Article 10 of the Constitution. My Lord, the sixth respondent submits that the manner in which the election process was managed by the fourth respondent, up to and including the tallying, verification, and the declaration of the results, flies in the face of the provisions of the articles that I've cited. As will be seen in the affidavit of Irene Masit and corroborated with the affidavits of the other form commissioners, the chairperson excluded the majority of the commissioners from the tallying and the verification process. In fact, if you go through the affidavits, you will note that the only duty that they were assigned or that they undertook as regards verification and tallying was when they were summoned by the chairperson to be given the results in the office. My Lord, and the other thing that they only did is after he told them, this is the results I'm going to read, was to give them the Form 34C. They did not take part in the tabulation of what resulted in Form 34C. My Lord, the sixth respondent had a legitimate expectation that as stipulated under 138 3C, that the tallying and the verification ought to have been done by the commission and not by an individual commissioner in the person of Chebukati. In fact, the exclusion of these commissioners did not start at that point while they were in Bomas, but it started at the point when he, Mr. Chebukati, unilaterally reassigned them duties that they would take at the floor of Bomas, which were completely at variance with the duties that they were holding as in the subcommittees that were running at the commission. Before the declaration of the results, the commissioners were expected to ascertain and satisfy themselves that whatever was being put into 34C was a true reflection of the contents of 34A and 34B, but they were never given that opportunity. My clients and the three commissioners have confirmed that they were not involved in the process at all that gave birth to 34C. Even during the declaration of the results done by the four commissioners, evidence that can be found in the affidavits shows that the only things they were given were handwritten pieces of paper with results in them. Those documents that they were given and which they were reading out to the public are not part of any accountable documents that can even be brought to this honorable court. Secondly, at the time of the declaration, my lord, you will note that there were 27 constituencies whose results had not been verified. Even though the chairperson claims that they could not announce or declare the results of those 27 constituencies because of the chaos that erupted, but they had an opportunity again when things were calmed down and they came back to declare the results of the presidential elect. Can it therefore, my lord, be said that the process that led to the declaration of the results were transparent, were accountable, or were verifiable if indeed the declared results were accurate? My answer and the answer of the sixth respondent is in the negative. In respect to my client's position as to whether she accepts or agrees with the results that were announced, at paragraph 73 of her affidavit, she states that without verification of results from the 27 constituencies, I believe it was not possible to determine a winner in the hotly contested 2022 presidential elections, and to that extent, I cannot vouch for the veracity of the result declared by Wafula Chebukati on the 15th, for there was no transparency on his part towards the declaration of results and final figures and were not verified. I was kept in the dark by the chairperson with respect to tallying. That is her position. She cannot vouch for the results that declared William Ruto as the president-elect. My lord, lastly, the conduct of exclusion by the chairperson of the other commissioners from vital activities of the commission was not limited only to the events that happened at Bomas. I will just cite a few. One of them was the manner in which he assigned the commissioners' roles to play at the Bomas. That was a unilateral decision. Secondly, the unilateral deployment, transfer, and gazettement of returning officers nationwide. That can be found in the affidavits of the sixth respondent at paragraphs 16 and 17. Then the third one is the deliberate failure to facilitate the contract implementation committee to oversee the implementation of the ballot papers, contracts, and task of inspection of the printed ballots at the vendor's factory in Greece. That is a function that ought to have been done to ensure that there was due diligence of the ballot papers that were being printed. That one, again, they were not involved, and that did not take place. Lastly, second last is the postponement of the elections in specific areas, including Mombasa, Kakamega, Kacheliba, Rongai, Pokot, South, among others. And lastly was the appointment and gazettement of the chairperson as the national returning officer. That, again, is not a decision that was taken by the commission unanimously. My Lord, in the end, it is apparent that in managing the affairs of the Commission with regards to the elections, the fourth respondent as the chairperson deliberately created a dysfunctional system to aid and abet his criminal and evil acts that would be interpreted to mean that he had intention to subvert the sovereign will of the people of Kenya. We beseech you, therefore, to find that nothing good can come out of a dysfunctional body. I'll therefore call my learned friend Jeremy to continue.
Yes, my ladies and my lords, I'll be very brief. My learned friends have touched most of the issues. My name is Jenga Jeremy, appearing for the 8th respondent. I want to give time to my learned friend Issa Mansour. So just a few points for clarification. One, speaking for the 8th respondent. My ladies and my lords, the 8th respondent per se, because of his position, is still a commissioner with the IEBC. He does not want to be classified as opposing or supporting the petition. But the reality is this, that by him, and I think that's the position of the other, from the 5th to the 8th respondents, by telling the court the truth, by telling Kenyans the truth, what happened at IEBC before the elections, during the elections, and after the elections, by telling the court the truth, unfortunately, they have no apologies for this, that evidence addresses some of the issues that have been framed by the court. One of those issues that, according to the 8th respondent, is addressed by his position, the one that is taken in his affidavit, is issue number 6. That is whether the IEBC carried out the verification, tallying, declaration of results in accordance with Article 138. My learned friends have covered that. The 8th respondent's affidavit has covered that. They were not involved in the tallying verification. So answering that question, the 8th respondent, it is his position that the presidential elections that were announced by the 3rd respondent did not comply. Now, the other issue that I want to clarify, my ladies and my lords, or maybe I should address whether the issue number 1, 5, and 7. Again, because of the peculiar nature of the way the IEBC is run by the chairman, it is the 8th respondent's position that despite being a commissioner, he cannot even help the court in addressing those issues because the results that were announced on the 15th of August, the systems that had been put in place, the person who was in charge of them, it was not the commission, it was not IEBC, but that is the chairman. The chairman is the one who can be able to answer most of those questions. The results that were announced, his position is that those were not the results of the commission, those were the results of the chairman. Maybe the other issue that I should mention is that the 5th to 8th respondents, they've been branded all sorts of names. Some of them appear in the documents that are before court. Others have been mentioned out there. And my lord, what the 5th to the 8th respondents did by walking out of Bomas is because they did not want to give legitimacy to a process which they were not involved in. My lord, by taking my ladies and my lords, by taking the position they did, as has been mentioned by my learned friends, they took an oath of office. And the oath of office that they took was to uphold and protect the Constitution. When they realized that the Constitution was being abused, their role that they were supposed to play was being abused by the chairman of the commission. That's why they took that position. Did they take that position so that they could support any of the parties? My Lord, that is not the position. They were just exercising their right, what they had taken oath to do, uphold and protect the Constitution. So all these names, the way they are being seen, that like they are taking sides. They are not taking sides because they had any interest in the outcome of the elections. They took the position they did because they wanted to uphold the Constitution. My ladies and my lord, we have there are some authorities in our list of authorities that we would kindly request that you look at them. I know you've been referred to authorities within Kenya. We have gone out of the country. We have some very good authorities from India, the Supreme Court of India. I will not take time to go through them, but they will be of great help to the court even as you retire to come down with your judgment. My lady, because of constraints of time, I will leave the remaining time to my learned friend, Mr. Issa.
Good evening. My Lady Chief Justice, the Deputy Chief Justice and Justice of the Supreme Court. My lords and my ladies and my lords, in summarizing the position of the 4 commissioners who are now respondents in this consolidated presidential petition, lords, we want to make the following submissions. One, as a commission, it is the position of the 4 commissioners that they did what was within their mandate to deliver a free and fair election as required by the Constitution. But in their quest to do what is right, what is required of them, there are problems that have been set out in the respective affidavits. And my lords, the first issue that you would note that springs from these 4 affidavits by the 4 commissioners is a question of lack of transparency. On the day after the voting ended, and also predates the general elections. You'd note one thing that is common and that cuts through the 4 affidavits is that they were excluded from the process that was going on in terms of verification. And what is clear when you look at all these 4 affidavits is that, yes, there was that process where they appeared to read results. These results, and they've said this under oath and has not been controverted, were the results that were being processed on the floor of the National Tallying Center. They were handwritten. And that's important because they were handwritten. They would come out and read them to the agents and to the nation so that for each and every constituency, and these results were per constituency, people would know that these results have been verified at the National Tallying Center. You would note that in this affidavit, for the first 2 days, from the 9th to the 12th, these results were being posted or they were being aired in a screen that was available to the agents, the presidential agents, and to the media. That screen was paused or it went off. In all the affidavits, they said and they requested that this screen should be on so that as we go progressively verifying and tallying the results, anything we announce here can be confirmed by both the presidential agents and by the voters who voted. That request was declined. The question is why? Why did the chairman refuse to put on those results and to verify the numbers that were being read to the nation? The second question that you'll see that arises in terms of the process of verification and tallying. That has been covered by some of the parties that have submitted today. You'd note that when that process reached the tail end, the 27 constituencies that had not been announced had not been publicly confirmed to have been verified. And in fact, when you look at the affidavit of Commissioner Wanderi, he says he had taken a break because he had been there overnight. When he came back, the first expectation was that these results would be confirmed, they had been verified, and that they had been announced to all the agents. The chairman takes the position there was no constitutional requirement, or he had no legal requirement to do that. No, he had. Because the Constitution requires transparency and accountability. That is a process that takes place at the National Tallying Center. It is not a perfunctory exercise. It is not a ceremony. It is a constitutional process. And why this is important is that the document that was given to the commissioners by Mr. Marjan, as confirmed by Mr. Chebukati, was not a Form 34C. That was being undertaken not by the commissioners, but members of staff in the back office of the chairman. The commissioners did not see Form 34C, did not verify it, and they did not approve it before it was generated. In fact, in all of their affidavits, they said they never saw the Form 34C. What was given was a 3-page document, and that document has a problem. That document appears in the vice chairman's affidavit and the other 3 commissioners' affidavits. What you note about that document, and that was generated by Mr. Marjan, as has been confirmed, and presented to the commissioners, is a summary of 47 counties. It does not have the results that are required to be confirmed and verified at the National Tallying Center of the 290 constituencies. Why is that important? Because at this point in time, before the Form 34C can be generated, these 7 commissioners, and I'm talking to them as a commission, needed to verify that what we have announced before the nation and to the presidential agents these are the results that have been announced publicly, and this is what has been tabulated for each and every constituency, and these are the results garnered by each and every candidate. And on the basis of that, then a Form 34C is prepared. That 3-page document is not a Form 34C. That is a document that the chairman came with, or he was presented, and then he went and declared the result. That was unconstitutional because the Form 34C needs to precede the Form 34D in terms of the commissioners approving that document. And because that is their role. That is a constitutional role. In fact, we engage these commissioners. We invest the billions that we invest in the commission so that when this solemn exercise comes along, every 5 years, that process, they take it seriously and they do it in accordance with the law. And the third issue about transparency. The commissioners were not aware of how many voters, and that figure was not confirmed at the time this figure was being given to them. The figures, and you'd note about the different figures that have been given, and in fact, I was asked to highlight this. When you look at the affidavit of Mr. Sonkuli, sorry, let me start with the chairman, Commissioner Chebukati, at paragraph 30 of his affidavit, the one that he saw, sorry, on the 26th of August, this is the one that has been prepared jointly by the firm of Gumbo and Company, my good friend. At paragraph 30, he gives the percentage 64.6. In Mr. Sunkuli's affidavit of the same day, and I know that an explanation has been given, on the 26th of August, at paragraph 25, he says at the close of voting that the turnout that had been reported in Kimskits was at 63.6%, and he gives the figures. Now, the commissioners needed to verify and confirm what the turnout was. And that required, and this is in public knowledge, and it has been confirmed by all the commissioners, that in a number of polling stations, the Kimskit failed, and they, in compliance with the law, they resorted to the printed manual register. The number of voters who voted without being biometrically verified had not been verified and confirmed by the commissioners. In fact, that information was never given to them. The number of voters who had been confirmed as having voted biometrically had not been given to the commissioners. So yes, they cannot change any of the results, but the process of verification and tallying and the constitutional process of determining who has attained the threshold is a joint process by all the commissioners. And that's where they come and say, what is the voter turnout? They confirm that process, because yes, they cannot change anything in the Form 34, even if they see glaring illegalities, they can note them. 2, that transparency required, then they confirm, because this Form 32As are not transmitted electronically. They are brought by this individual, returning officers from the 290 constituencies. There was a possibility. There were some places where voters could not be identified because their biometrics had a problem, and they could not be, and then there was, and that was allowed by the Court of Appeal. The final resort was to resort to the register, the printed register, to confirm that these persons, because they had the IDs of were registered voters. That is also a solemn process, because then they confirm, out of all this, were there any other voters that were identified manually, and then that number is verified, so we can come to the determination whether the 50+1 had been attained. They were not allowed to do that. And they requested, it's not that because there was an oversight, they requested and the chairman declined. So this transparency at the National Tallying Center is critical, because as a commission, you have to come and defend the process from the Gazette notice that was issued in January of 2022 to the final declaration. And the fact that the chairman was stubborn is a question, as set out in these 4 affidavits, is that he has contempt not only for his fellow commissioners, but also for the voters, and also for the people of this republic, as well as the institutions, because that's exactly what he was told as the chairman, not him as a person, in Maina Kiai, that the chairman of IEBC does not have that role singularly. That is a role vested in the commission. Failure to adhere to a decision that is binding on the commission and the chairman of the commission is contempt not only of the Constitution, but of the institutions, of the judicial institutions that have said this over and over again. And let me go back to the lack of transparency in the process. When you look at the affidavit, which is the most detailed of the vice chairperson of the commission, there was lack of transparency regarding even when the ballot papers came to this country. The chairman calls the vice chairperson the night before the ballot papers are to land here and tells, oh, you are aware that tomorrow we are getting ballot papers. The other commissioners were not aware. This is part of the critical process that was meant to be undertaken by the commission. So transparency is just not at the tallying center, it's about the whole process. Well, if you look at paragraph 8 of vice chairman of the commission, Juliana Cherera, she says, when it came to the issues raised about the voter register that were being addressed in one of the petitions, serious issues had been raised by KPMG. And so that required prompt, because this process was already late, it required a plenary decision on how to address the shortcomings and the lack of integrity of the data in that voter register. The vice chair says they were excluded from that process by the chairperson. So if there was any problem with the voter register, it was meant to be addressed by the commissioners, because they take ownership of the voter register. They were excluded. He made the decision on how to implement the decision and even what to disclose to the public. So these are the processes we're saying. Transparency and accountability in the whole process, and Article 81 and 86, is just not about the final product that appears on the telly. It's about what the commissioners are meant to do. And lastly, when you look at the affidavit of Commissioner Justice Nyang'ai, if anyone was to be given access to the voter identification, the result transmission system, or the back end, the commissioners needed to know we are giving the following persons access and the following rights, so that if there's any query, they can answer on behalf of the commission. That information was kept away by the commissioners, from the commissioners. In fact, the commissioner in charge of that process. Lack of accountability and lack of transparency. And then these 4 commissioners who are being vilified are expected to come and stand behind the chairman and take ownership of such a process that has so many questions and then confirm that a person has been declared the president without following due process under the Constitution. They took an oath, and they have a responsibility and a constitutional obligation to the voters and to the people of Kenya not to take part in such a process. And that's what they did on the day of 15th. And that day of 15th is important because if it was the last day, there could have been an explanation as to why the chairman was in a hurry. There was one more extra day. Why was the chairman in a hurry while the choir was singing, the country was peaceful? He had one more day to ensure that the whole process was undertaken in a manner contemplated under the Constitution. And so, my ladies and my lords, we submit that these 4 commissioners, and although they have taken a position here and they've now been, they've been sued as respondents, had every right not to give a seal of approval to that process that was not verifiable, it was not accountable, and had not been undertaken in conformity with the Constitution. They respect the work that all the voters, all the staff at the Commission had done, but they were betrayed by the chairman. Thank you, Chief Justice and judges of the Supreme Court.